Move on to probation. Probation plays a major role in the sentencing of many offenders here. And when an offender is placed on probation, they are ordered to comply with strict terms that it's agreed upon by all parties in the court. When offenders violate these terms, the probation department notifies the state's attorney's office. How should offenders who violate the terms of probation be dealt with?
Well, it in part depends on the seriousness of the violation. If it's a first-time violation and it's a more minor violation, then you could deal with it substantially less severe than a major violation. But I guess there's always the possibility, or I believe should be dealt with progressively. I believe one appropriate way is to have a probation violation. Depending upon the seriousness of the crime, you may start out with requesting, potentially a short jail sentence. If it's a serious felony offense, you may wish to seek a Department of Corrections time. But I believe that depending upon if it's, say, a minor violation, say they missed a couple of appointments, then with the probation department, that may be more appropriate to request, say, a short county jail sentence. If it's a more serious offense, such as other criminal offenses, repeatedly violating or refusing to go to probation appointments, repeated dirty drug tests, refusing to allow the probation department to go to your home as required by a probation order, then if it's a felony offense, I think it'd be appropriate to seek a sentence in the Department of Corrections. Thank you.
Mr. Weiss, 1 minute.
Yeah, I would just point out, I guess, for the general public to keep in mind that sometimes when you may not have the greatest case in the world, or you may have a witness that is changed their position or unwilling or unable for whatever reason to come through. And sometimes you're better off agreeing to put certain defendants on probation when you know that there's no way that they're going to be to pass probation, and without violating their probation. At that time, you can send them back to, or send them to the Department of Corrections.
Thank you. Mr. Weisman, the state's attorney plays a major role in county government, as you know. The position is the primary legal authority for the county and the county's legal advisor in a lot of cases. What's your definition of the duties of the state's attorney as it pertains to legally representing and advising the county board?
Yes, that's true. It's a complex job. There's a lot of different facets and a lot of different things that the state's attorney's office is called upon to handle and assist and give advice on. I feel that I've done a very good job of staying on top of those things, and that it's interesting work, and it's somewhat similar to being an advisor almost to a large corporation in that respect, and it's a side of the job that probably a lot of people don't really think about a whole lot about, but it's been very interesting. There's always a lot of difficult issues. There's labor relation problems. You've got problems dealing with overlap of jurisdictions, and so it's not they're not always easy answers, but like anything, work diligently, and you can usually solve a problem.
Mr. Rector?
Thank you, Officer Danks. Yes, it's true that the state's attorney is a legal advisor to both the county board and to all the other elected officials of the county, the circuit clerk, the treasurer, the supervisor of assessments is actually an appointed position, the county clerk / recorder. But the role specifically of the state's attorney in those regards is something that I did actually frequently address when I was the state's attorney in Champaign County. I routinely when I was in that position, would attend county board meetings as an advisor to the county board. Further, I specifically gave opinions to the county board in Champaign County where I was an assistant state's attorney on with regards to election law, labor law, and a variety of ordinance issues concerning animal control. But I think it's very important that the state's attorney be on top of all those issues, and also that he have a good relationship with the various elected officials and county board members. Thank you.
Okay. Final question is yours first. All law enforcement agencies in Crawford County submit their completed investigative reports to the state's attorney's office for prosecution. Now, he may use his discretion to determine how to move forward with the case, and that discretion is his. He may choose to prosecute or dismiss the case. Now, dismissals are often published in the local media, and the most common reason for dismissals is when a person has multiple charges and pleads to one of them, and the other charges are then dismissed. That's pretty common. But what are other circumstances that would necessitate the dismissal of a case submitted by law enforcement for prosecution?
Well, I think that a very important factor that needs to be considered is ultimately the state's attorney makes the decision whether or not to even file or begin charges to begin with. And the state's attorney needs to have a thorough review of the evidence of the case before he decides to commence legal proceedings. That other than for plea agreements, I think that the only particularly legitimate time to dismiss the case is if the state's attorney makes a determination as to that there's a legal insufficiency to the case, or specifically that he is unable to, in his opinion, prove beyond a reasonable doubt the legal sufficiency of a case to a jury or a judge in Charles held. So other than for grounds of plea agreements and legal insufficiency, I don't currently, or I guess there'd also be the other possibility of if a case potentially could be legally sufficient under the statute, but the statute is of dubious constitutionality, that the state's attorney should make a consideration as to whether or not he wishes to pursue prosecution of a statute that he believes is unconstitutional. I believe those would be the only factors that would be appropriate. Thank you.
Mr. Wiseman?
I do believe that in a particular case that I'm thinking of, and that involved constitutionality of the statute, that I think that I would not proceed any further. If I felt like it was unconstitutional, then it would not proceed any further. And only in cases where I feel like it would be, if it is constitutional, would I continue with the case. Dismissals, of course, as you point out, yes, that's true, and I think most people probably here understand how there's multiple charges, and the person usually pleads to the most severe charge, and the prosecution gets conviction, and that some of those charges, are going to be dismissed as part of doing the necessary movement of cases. And also, it's been true in this county, as I'm sure in all counties, actually, that in the newspaper, of course, prints dismissals, and they do a good job in the newspaper. I'm not faulting them at all, but it would be better explained to the public if they could have explained that they pled guilty to another charge instead of just putting a whole column of dismissals where it looks like cases are just being wholesale dismissed.